Lawsome by ConsultWebs. Breakthrough insights to build a thriving law firm with your host, Tanner Jones.
All right. Hello, everyone. My name's Tanner Jones, and welcome to the Lawsome Podcast by ConsultWebs. Today on our show, I am so honored to be speaking with Judge Bob Bacharach of the 10th Circuit Court of Appeals. I've been looking forward to this conversation today, Judge. Welcome. Very happy to have you.
Well, I'm delighted to be here. Thank you so much.
Absolutely. So you recently wrote a book entitled Legal Writing, A Judge's Perspective on the Science and Rhetoric of the Written Word. And in that book, you draw on several lessons for effective legal writing and communication, hugely valuable lessons forged in the legal trenches, if you will, and conveniently laid out in your book. But before we get into those details, I'd like to first start just with your legal career, your background. Do you mind summarizing that for us?
Sure. In 1985, I graduated law school from Washington University at St. Louis. And then I clerked for 2 years for the then Chief Judge of the 10th Circuit. His name was William Holloway Jr., passed away about 7 or 8 years ago. And then in 1987, I went to a law firm in Oklahoma City, where I'm from, and practiced in litigation for about 12 and a half years at a firm called Crowe and Dunlevy. And then in 1999, I was appointed as a United States Magistrate Judge for the District Court in the Western District of Oklahoma. And then in 2013, I was appointed by President Obama to the 10th Circuit, where I've served since then.
Very good. Well, we are grateful for your service there. And I know, you've obviously had a lot of years leading up to writing this book. I'm really interested to dive into this topic. As you well know, Lawsome, the podcast here, we serve the legal community, mostly attorneys, legal professionals, as well as legal marketers. And I'm really curious to hear specifically on the book itself, what was the intended purpose? What is the problem, if you will, that the book is solving?
One of the problems is that as lawyers, we're accustomed to doing what we had learned to do, and prior generations that had taught us did what they had been taught to do. And as a result of that, Tanner, over the years, legal communication has been very difficult to follow. And in recent years, there's been a movement called the Plain English Movement, which is just people that have this very common sense notion of let's try to actually communicate in ways that people, lawyers, non-lawyers, can understand. And it makes our communication so much more effective and so much more persuasive. And that's what I'm trying to enhance through the book.
I love that. The concept of less is more has always stood out to me. The concept of just simply plain English, communicating effectively can go so far in anyone's career, especially legal, obviously, but this is valuable for anyone. But I know in the book you walk through particular steps in order to basically an action guide on how to effectively and clearly communicate. Can you walk us through those steps in that process?
Sure, Tanner. One of the important steps is to contextualize details before the reader gets to the details, which is a fancy way of saying that in any document, and it could be a non-legal document as well as a legal document, there's going to be a lot of detail. And when we read details, we all struggle if we don't know the meaning that is to be extracted from those details, why the author has given us those details. So that's what I mean by creating context before the reader plunges into the details. And the second step is to simplify your diction. Lawyers are accustomed frequently to using legalese, Latin phrases, which are absolutely abysmal if our job is truly to try to communicate effectively and easily with our readers. And also just using $64 words when a $2 word would work just as well. And then thirdly is to try to link information in the document. And what I mean by that is a lot of us will resort to things like if we're telling a story that, well, on this date, such and such happened, on this date, such and such happened, and the reader really has no substantive way to interconnect those two pieces of information. And so one of the ways that I think we can enhance the clarity of our legal writing, Tanner, is to give substantive information when we link different pieces of information in our legal documents. And lastly, to just create chunks of information. Years ago, we were told, keep all your sentences short, and many people still observe that. But what psycholinguistics tells us, and psycholinguistics is simply a discipline of psychologists that for 50 or 60 years have been studying how the brain processes language. And what they tell us, Tanner, is that when we process information, we don't process an entire sentence, even a short sentence. We have familiar units of meaning. It could be a clause, it could be a word, but it's something that we can store in our short term, our working memories. If you think about your telephone number, for example, it's 10 digits, but if you were to tell someone your phone number, you start with the area code, and if you write it, you'd put that in punctuation and parentheses. You'd put the 3-digit prefix before another piece of punctuation, a dash, and then the last 4 digits after the dash. And that's because that's how we process information. And so if we think about how our readers process information when we write, I think our readers will be able to understand what we have to say far more easily. And so that's the last step that I would describe in terms of enhancing clarity, is to convey the information in, that's what I mean, meaningful chunks.
Very helpful. And makes, obviously practical sense in working through that. I'd like to, if you don't mind, I'd like to dive into these a little deeper, if we could. For example, maybe giving some more context. And related to number one, creating context before detail. So let's dive into this a little better, just to help the listeners here. Are there any examples maybe that you can tie to this, just to bring it to life a little more?
You bet. One of the effective devices is to create a meaningful introduction. And I'll give you an example. There was a case a number of years ago that Chief Justice Roberts wrote. It was a case called Conkright versus Frommert. And what it involved was a pretty complicated ERISA issue. But what he does in the first 100 words or so is the first 2 lines are people make mistakes, even administrators of ERISA plans. And then what he does is he quickly segues to tell you one legal principle, that there was a case called Firestone Tire and Rubber Company versus Bruch, in which the Supreme Court held that plan administrators are typically accorded discretion in administering ERISA plans. And then he tells you in the next sentence that the plan administrator in this case made a single honest mistake in interpreting the plan. And then he lays out the issue, whether that single honest mistake would prevent the court from according discretion to the plan administrator for any other related interpretations of the plan. And so what he does is he creates, in just a little over 100 words, using very simple English, the overarching legal context, the overarching factual context, and he does it by being really stingy in the information that he gives the reader. He's doing that because it's very easy to overwhelm a reader with too much information early on. So all he's trying to do is to give an overarching context, sort of like the Cliff Notes. If you read War and Peace, which I never have, but if you start with the Cliff Note version of it, it's going to be so much easier to read. And that's what I would suggest is one of the effective ways to do it, is to create a meaningful introduction. But you can also create context through using substantive headings, meaningful headings. And I don't mean like background discussion, by telling the reader in a declarative sentence what it is that the point of this section is. And using meaningful headings in that way that can contextualize the details before the reader then plunges into the details. And then the last example that I would give, Tanner, is just using topic sentences. It's something that's rarely done in legal documents or non-legal documents, but topic sentences are a very effective way to create the context for the details that are to come in any paragraph.
It's so fascinating hearing that, Judge, because I appreciate it so much. I come from marketing background, marketing and sales, and the value of basically focusing your information. There's so much, like with internet marketing, and we won't get too off track here, but with internet marketing, it's a very complex area. Lots of dynamic elements with a successful campaign. But what we have to do from a marketing standpoint, much like any other business marketing, is to simplify the message. And that context is so important. Not everyone is living their life in this world that we're in, and so being able to frame it up is a valuable piece. And so I can most certainly relate from that standpoint. So moving right into this next piece, the concept of avoiding legalese, simplifying language. I'd love to dive a little deeper in this one as well, because I think it is very common. In fact, I think I'll just call it out and be candid in this conversation that knowing, I think the society as a whole tends to expect lawyers to come to the table with, bigger words and more education. And so, I wonder if there is some level of expectation, even if it's a false expectation on a lawyer's behalf, to kind of, follow that line. But how is that ultimately impacting their effectiveness in legal writing?
Really, that's exactly right. And I think many of us resort to legalese and Latin phrases because it is expected of lawyers, of judges, but it is such an impediment to clarity. If our job as a writer, whether you're writing a marketing piece or writing a judicial opinion or a brief, you want your reader to instantly understand with as little mental effort as needed to ascertain the content of what you're saying. And if you have a choice of using a Latin phrase like inter alia or the plain English counterpart, you're always going to be better off when you have those kinds of choices of using the plain English version. There was a study that was done a number of years ago by two law professors named Benson and Kessler. And what they did was they took a number of briefs that were written in petitions for rehearing in the California Court of Appeals, and then they rewrote these excerpts that were drenched with legalese into plain English. And then they gave these two excerpts to 33 research attorneys and 10 justices on this court. And the overwhelming majority of both the research attorneys and the justices, when seeing the plain English counterpart and the legalese counterpart, had a much greater preference for the plain English version. And so we're really at cross purposes when we resort to what we're trained to do, what we're expected to do, of using legalese and Latin. And the same is true for using a big word when a simple word would do quite nicely.
Yeah, well said. It's extremely helpful there, and I'm certain you've seen that. We've all experienced that, whether you've seen that in the courtroom or it's just us on everyday conversation at a coffee shop. We all kind of resonate to, or at least the connectivity aspect of communication is stronger, in my opinion, when you can simplify what you're trying to communicate. It's a powerful concept, yet seemingly so simple. The whole idea, the linking, so moving right into your step 3 of linking information in sentences. Let's continue down this path of exploring these steps a little more finely.
Yes, so when I talk about linking information, if you use a transition, say furthermore or moreover, you're really not imparting any information. There's a concept that's taken hold of a lot of the legal writing literature that uses the phrase of putting old or familiar information before new information. And what that's a fancy way of saying is that if you take part of the new content of what you have already told the reader, and you use that to start the information in the new sentence. What you've done very easily but effectively is you have subtly shown the reader how what you've just said will interrelate to what you're about to say. And there's a number of examples of this. If you look, for example, at FDR's first inaugural address, you will see that even so long ago, that what he would do frequently is start a new sentence with pronouns. For example, he used this and it a lot, and they were referring directly to what he had just told the listening public. And so by using pronouns to substantively tie in what he's about to say, he's letting his message resonate in an easy to understand way, because the listening public then understands, okay, now when he says this, I understand that how that relates to what he's just told us. It's very simple, but it's an effective way of linking the what I would call the old content and the new content.
That's powerful and seamless, right? I mean, it's efficient. The human mind can only process so much, and so being able, I see these as truly hacks, hacks in communication and effective communication. And I also hear this, I know we're talking largely around the written word, but as I'm hearing this, I'm certain we have a lot of clients and obviously a lot of lawyers across the country that are trial lawyers and standing in front of jurors on a routine basis. And I suspect a lot of this is going to serve them extremely well in, speaking to a jury just as it would in, writing a formal legal document.
That's absolutely true. And one of the things that I think all of us as writers can do more of is think about oral communication. And your example, Ted, of referring to trial lawyers is spot on. If we think about how we write, much like a trial lawyer thinks about his or her message in opening statement or in closing argument, all of us will do a much better job of enhancing the clarity of our communication, because no trial lawyer would think about trying to use legalese or Latin to a jury, or to try to use these sort of meaningless transitions like furthermore. It's just instinctual that a trial lawyer is going to try to unfold his or her message to a jury in an instantly understandable way. And unfortunately for many of us, when we get a piece of paper and a pen, we forget all of that. And so if we can emulate some of those lessons that trial lawyers do, every day of the year, I think we just do a lot better job of communicating and writing.
I agree wholeheartedly. I think that's big. Moving right along here, Judge, the step 4 or a piece of this that you had mentioned was the idea of chunking information. And in a prior conversation with you, you had brought up an example of Martin Luther King Jr.'s famous letter. I'd love for you to tell a little bit more about that, related to that concept, and share that with our listeners.
You bet. As I said, many of us are told to keep all of your sentences short, 20 words, 25 words. Martin Luther King Jr. had one sentence in that letter from Birmingham jail, which was just a magnificent letter in terms of communication. One sentence in that letter took 305 words. It was much longer than any sentence that you or I would write. And yet it is absolutely easily understandable. And it's because he breaks those 305 words into 12 discernible chunks of information. It starts out, and this is just this one sentence, obviously it's a lengthy letter in itself, but this one sentence that I'm speaking of starts out, "But when you have seen vicious mobs lynch your mothers and fathers at will and drown your sisters and brothers at whim," and then he's got a semicolon. So it tells us without thinking about it that, okay, we're going to have a sustained pause right there. Psycholinguists tell us that that's a wrap-up effect. When we get to something like a comma or a semicolon or a period, without thinking about it, Tanner, our brains tell us, okay, we have to digest this thing that we just read and make sure we understand it before we move on. And so our brains do that, psycholinguists tell us, whether we are trying to do it or not. And then he goes on. And then the second chunk is, when you have seen hate-filled policemen curse, kick, and even kill your black brothers and sisters. And then he's got another semicolon, and it goes on like this. One easily understandable chunk after another for 11 chunks, about 290 words. And then he ends this one sentence with his 12th chunk. And it's, when you are forever fighting a degenerating sense of nobodiness, then you will understand why we find it difficult to wait. In this one sentence, he's trying to communicate, this is why he and his followers are so impatient for racial justice. And it's because all of these things that he and his followers have seen, one racial injustice after another. And so the point is not the content of his message, which is a powerful message, but just in terms of his communicative strategy, he unfolds this very, very long sentence in these 12 digestible chunks that coincidentally matches what psycholinguists tell us. That's how we process his words, your words, my words, everybody's words. And that's one of the many reasons that he was such a marvelous communicator, is he used this strategy like very few people of his era or since.
I agree. And so I guess a follow-up question to that is, how does that apply directly to legal writing in your mind? What's the impact? What's the effect?
If we try to do the same thing, and if we tell ourselves that if we write a 40-word sentence, I don't think that there's anything wrong with that, as long as we have easily identifiable starts and stops for those chunks of information. For example, in his lengthy sentence, we know instantly where these chunks start and stop. If we have a 40-word sentence, or frankly a 10-word sentence that's divorced of punctuation, it's just a long string of information without digestible chunks that are visible to the reader through punctuation, commas, dashes, semicolons, then we make the reader try on the fly to figure out where these chunks start and stop. So if the message I would say is, as legal writers, if we make these chunks of information immediately visible to the reader generally by using punctuation. There's other types of typography that we can use, bulleted lists, numerical lists, that will easily and instantly communicate to the reader, okay, this is the first bullet, that's a chunk of information in and of itself. The reader, in other words, can process that, store it in his or her short-term memory before moving on to the next chunk. So if we import the same strategy, I think it makes it easier for readers to process.
Absolutely. Yeah, well said. Thank you for that. If you would take a moment, I know we've spent a lot of time working through these steps, and there's a lot of meat, there's a lot of value there. So if you could just take a few moments just to summarize that, the process to work through in terms of being able to reach the maximum potential in legal writing.
One of the important steps is, before a legal writer ever picks up a piece of paper or opens their computer, is to think about what you have to say and what information, whether it's factual details or legal information, you really need in order to make your argument. Maybe there's reasons that you are writing an appellate brief, for example, that shows that your client is in the right, but it really has nothing to do with the legal argument that you're presenting to the court. It's important to think about your audience. What do you, if it's an appellate court, they are going to be focusing on the issue that you are presenting to them to decide. And if you have extraneous information, even if it puts your client in a very favorable light and the opposing party in an unfavorable light, you have impeded the clarity of your message, because now you have the judge or judges thinking about something other than the issue that you are presenting to them to decide. So I would say to go through that sort of thought process, excise everything that's extraneous to your argument, whether it's legal arguments or factual details, and then to think about what is the sequence of what is the progression that you want the reader to follow. Not necessarily matching the process that you as an author went through, but much like your example of marketing, what is it that you want the reader to seize upon when he or she reads your message? And I think if we think about our legal messaging in the same way as we think about marketing messages, I think we will make our arguments far more concise, far more logical, and importantly, easier to follow. And then I think if we use these devices of creating context and simplifying our diction and linking information and putting our information in chunks, those are the final steps, I think, that on top of a clear, concise organization will make our messaging as easy to follow and as powerful as we possibly can.
That's great. Thank you, Judge. Well, any other tips? I know we've covered a lot. Any other tips for our listeners around this subject that you think would be useful for them in implementation? One of
the other comments that I would make is be ruthless in editing your own work. The people that are the most talented legal writers very rarely are able to write such skillful, concise prose in their first or second draft. It takes a lot of ruthless editing and thinking about editing in terms of putting yourself to the extent you possibly can in the shoes of someone who is a neophyte when it comes to this material, that they're not familiar with the content. If you're writing a legal document, give it to a non-lawyer. And any non-lawyer should be able to understand it. And if they struggle, then I promise you that there's going to be lots of lawyers and judges that are going to be struggling to understand it as well. So that would be the only other suggestion, Tanner, is to just be very mindful of the need to edit and then edit some more.
And I've seen that in my own profession, just the value of gaining perspective. I mean, first and foremost, the value of being intentional, and thinking through how will this information be processed. We use a lot of acronyms in marketing and, in search marketing, and I've had to force myself out of the habit of just, allowing those acronyms to roll off my tongue or in written communication, because you're right. A lot of the audience, they are not in this world every day. And the more we can back up and do our best to see that, you're going to ultimately create a better product in the end. And I'll add too, gaining perspective is huge. We're all crafted uniquely. We all interpret information uniquely, and we all have very different personalities. And so the more perspective you can gain, ultimately the better you're going to be able to communicate to the whole, versus just communicating to more of yous around. That's a big piece. Thank you for that. Well, I would like to actually take a moment to learn a little bit more about your book. I know our audience, the ones listening may be interested in digging in on that. So if you could give a recap on the book itself. What we'll do too is we'll include information if you want to reach out to us. If you're listening, we'll include information to be able to offer the book or get access to the book using a discount code. So I do want to mention that. We're more than happy to pass that along. But yes, please, Judge, give a quick summary on that.
It's the publisher, and thank you for asking. The publisher is the American Bar Association, ABA Press, and it's available through the ABA publishing website. And I'll be glad to I don't have it in front of me, unfortunately, but I'd be happy to send that to you. And there's an 800 number also that people can use the discount code to order the book.
Perfect. We'll make sure we pass that along to those interested. I'd like to end, Judge, with just one question, and I think this is always good for our listeners to hear, directly from those in your shoes. Specifically, if you could go back in time, in your early career, what is one piece of advice that you would give yourself in starting your legal career?
If I were speaking to a young Bob Bacharach starting out his legal career, I would say, you're going to make mistakes. And when I was 25, graduating law school and starting a legal career, I thought, well, if you make a mistake in a law firm, you're going to be banished from the law firm, and your legal career will be over. And many of us as young people think that way. And then as you age, you realize all of us make mistakes every day of the week. That 99.9% of the mistakes that we make are correctable. And it's really what's a defining characteristics of our profession is how we handle those mistakes. Do you own up to it, or do you blame other people, your secretary or your associate? And those are the sort of qualities, I think, that distinguish many lawyers in terms of character. But I think that it's important for young lawyers particularly to realize that, yes, the legal profession is a noble profession and you will work hard, but realize that you are a human being. If I were to, the first 3 words of that introduction that I mentioned of Chief Justice Roberts, the first 3 words in that opinion, Copyright versus Frommer, are people make mistakes. And that's true of lawyers, no matter how hard we work. So that would be my main message to a young Bob Bacharach.
Powerful insights. Thanks so much. Judge Bob Bacharach, thank you for joining us.
Thank you so much. It's been a delight.
Lawsome by ConsultWebs with Tanner Jones. For show notes, links, and info, go to consultwebs.com/podcast. Be sure to subscribe and leave us a review. Watch for the next Lawsome episode to discover more breakthrough insights to build a thriving law firm.